I'm Michael Henley, CEO and founder of Brandywine Private Wealth, joined by Matt D'Amelio, one of the top estate attorneys in the industry. So let's jump in, Matt. Let's talk about probate and why should all clients try and avoid probate?
Probate is the process where you file your will with the local Register of Wills office, and the Register of Wills office supervises, if you will, the process of distributing the estate. There's a cost to that supervision called probate fees. In some jurisdictions, they're expressed in a percentage, and in other jurisdictions, there's just a chart of, if you have between X and Y, the fee is what it is. Probate fees are essentially voluntary. Any asset that is jointly owned, has a beneficiary designated on it, or is titled in the client's revocable trust will avoid probate and not be subject to those probate fees.
Okay, so if my mom passes away, $1 million, and she has a will only, that's a safe assumption that there's going to be probate involved in that settlement. Is that correct?
Yeah, if that $1 million is in an investment account in her sole name, then that would be a probate asset and you would pay probate fees on it.
And is probate public? Is that a public settlement? Is that a...
Yeah, filings in the probate court are available to the public.
Oh, wow, okay. So no privacy whatsoever.
That's correct.
Okay, got it.
Revocable trusts, on the other hand, are private and not filed in any office.
Okay, so if you don't want the general public to know your personal assets, avoiding probate is critical.
That's correct.
Okay, got it. What if I own property in another state? Let's say I'm a Delaware resident, but I have a second home in Florida. Can I have probate in a different state?
You can. If you own real estate or other property located in a state other than the state that you were domiciled, state that you resided in, then there would be what's called ancillary probate that's required in that state. It's not necessarily quite as burdensome as the primary probate, but it is the process. It will cost money, it will take time, and it will delay the overall settlement of the estate.
Okay, so complications, fees, and what have you.
All of that is avoided with a revocable trust.
Okay, got it. If I have a will, it does not avoid probate at all. Is that correct?
A will does not avoid probate.
So just to clarify, use an example, if my estate plan says leave all of my assets to my kids, but I have a joint account with my dad, for example, something happens to me, that joint account with my dad is not going to my kids?
Yeah, and we see that all the time. People think that the will applies to everything because it was in their will. The will says it, so it applies. The reality is that each asset that someone has will be disposed of based upon the nature of that asset.
Okay.
So if it's jointly owned, it will pass to a joint owner. And absent some evidence that it was jointly owned solely for convenience, those assets now belong to that joint owner, and the joint owner has no obligation, no legal obligation to dispose of that or give that to the other beneficiaries under a will.
Okay, because oftentimes clients will add themselves as a co-owner to mom or dad's bank account as they get, in their later years for convenience reasons. That can get pretty complicated, huh?
Yeah, there's a couple of reasons why you may not want to just retitle assets as jointly, as an inexpensive way to avoid probate. The first is when you make an asset joint, those assets become subject to the creditors of the joint owner. So, if your son or daughter, in your example, were in a bad car accident and sued, the client is now putting their own assets or some portion of their own assets in jeopardy. The second reason is the joint owner has no legal obligation to fulfill the terms of the will. Instead, those assets pass to the joint owner, and the joint owner can do with them as he or she pleases.
Got it, okay. It's a bit complicated. If I establish a revocable trust in an effort to avoid probate, do I have to retitle all of my assets to the revocable trust, or how does that piece work?
It depends on the nature of the asset. So assets that are solely owned, you would want to retitle into the name of the trust. Assets that have beneficiary designations, you would want to change the beneficiary to the trust.
Okay.
So that way at death it funnels in. A good example of that would be a retirement account. You can't actually retitle the name of a retirement account, but the owner of the retirement account does have the ability to change the beneficiary. So you would funnel it into the trust.
What about something like cars or collectibles? Can vehicles be retitled to the name of a trust, or how does that work?
Vehicles can be retitled to a trust. I think it depends on the circumstances. For a lot of people, vehicles are not kept for long periods of time. So, it may not be worth, if doing a plan for someone to have them rush to the DMV to make a change. But buying vehicles jointly could be helpful
Okay.
with husband and wife so that you don't have a probate issue. You can put vehicles into a trust. You just want to make sure that you check with your insurer to make sure that the vehicle is properly insured.
Got it. Thanks everyone for watching. Hope this has been helpful. If you have any further questions on estate planning in general, feel free to scan the QR code to see how we might be able to help.